Welcome, everybody. My name is Marty Mascari. I am a contractor under the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments. We are for those of you joining us from outside the state or around the state, we are in the greater Dallas-Fort Worth, Texas area. And we are blessed once again to have our friends at Heyman Hogue, Sheila Williamson and Rex Hogue, here to talk about living trust in detail. But before we get started, we're going to do a little bit of an overview of the CEUs that we're offering today and what the requirements are, so we let all of you that are joining us understand that. And we also can do a certificate of attendance if you're looking for that. But Sheila, I'm going to let you go over that. If Rex, you could advance the slide one, that would be great.
Good afternoon. We're so glad you could join us today, and from all over the United States, and lots of you from the Metroplex, and that makes us very happy. Today, we're going over a living trust in detail, but the procedure is the same to get your CEUs. There will be 3 forms mailed emailed to you by Marty when he follows up with you. There will be a disclosure form, which you do not need to send back to me. What that is stating is that we do this for a living, but that this talk is strictly educational only, because an educated public is better for all of us. That's what that is. That's for your records. The other 2, however, I do need back. One is a sign-in form, and one is an evaluation form. Just like any CEU, I have to have both of those to issue your certificate. Once I get those sent back to me, not to Marty, but to me, then it will be clear and I will email you your certificates. Very simple.
Very, very good. And in addition to the information for Heyman Hogue, these documents, we also have a Google survey that we ask you to complete. The Google survey is for us to collect information to report back on the goals and objectives we set out when we applied for the funding to organize these webinars. So if you please do both. The Google survey should pop up as you close out of Zoom today. It should give you the option to go to the survey and complete it. It should only take you a minute or 2 to complete it. But you will also receive a link to that in case you have a pop-up blocker that won't allow you to do that. You'll receive a link to that along with the documents that Sheila talked about in the follow-up email that will go out either this afternoon or tomorrow morning with the information. So if you look for that, we'd certainly appreciate it. Sheila, do you want to introduce Rex, please?
I will be happy to. When we started talking about, Marty had asked me, because so many of you had asked him, when we talk about, that's another thing. On the form, the evaluation form that you get, one of the questions asks you for topics that you would be interested in hearing presented. Please take the time, if you have any suggestions, to put those on there, because we do read those. And this is why we're covering this one today. Marty got a lot from you, and I did as well. And Rex is giving up of his time to do this today. I want to introduce my boss, Rex Hogue. Rex is a founding member of Heyman Hogue, but Rex has been practicing for more than 25 years. And I don't believe I've ever said this on here, but I am saying it today. He is known countrywide, United States period, as an expert in living trust. So he writes a lot of the documents for Wealth Counsel. Rex is tremendously experienced. Other attorneys do call him to ask for his input into things. And so you could not have a better presenter for this topic. So like Marty said, please put your questions in the Q&A or the chat, and I will make sure they get answered at the end. Without any further ado, Mr. Rex Hogue.
Okay, thank you, everyone. We're going to talk today about what a living trust should protect against and how it should work. So I always start with the administrative dragons. They're the primary dragons that we're going to deal with today, and those include power of attorney failures, guardianship, and probate. We're going to talk a little bit about medical documents, and those are the big green dragons that walk around on the ground. Then there are tax dragons, capital gains, gift estate, generation skipping transfer tax, business entity taxes, tax method, audit risk. These dragons are, they're not a lot of fun. They're the fire-breathing dragons that nobody really wants to see. And then there are predator dragons dealing with predator and creditor claims. And there's two aspects of this. One is protecting yourself and one is protecting what you leave others. And these are the dragons that some people think just come flying out of nowhere. Now, the administrative dragon is the primary one we're going to deal with, as I mentioned. How do you get a substitute signature when you cannot sign your own name? All estate administration revolves around this single issue. And this is the dragon that one way or the other, everybody has to deal with. Well, one way to deal with incapacity is with a power of attorney. A power of attorney is where a principal gives an agent a power of attorney. It's an invitation to third parties to let the agent act on the principal's behalf. There are two things you can do with an invitation. You can accept it or reject it. If the power of attorney fails, I'm going to ask this question: what's plan B? Well, a guardianship, which is a court-supervised transfer of assets for somebody who's legally incompetent, sometimes called living probate, is a plan B. And the other plan B is a living trust. And a living trust can replace the power of attorney. It can provide that necessary substitute signature, and it therefore avoids both guardianship and probate. It can also provide instructions for the incapacitated trust maker's care, and I'm going to give an example of that today. Now, why do powers of attorney fail? Well, Texas law is fairly extensive on this, but I don't want to focus on all the details of Texas law. Just imagine the scenario. You have been given a power of attorney by a parent, a loved one, a friend, and you go to an institution, maybe the bank. Well, here's the problem. The principal is not there to tell the institution that it's okay to take the power of attorney. If the principal isn't there, the institution, there's a lot of things that they do not know. They don't know if the principal is still alive. If the principal is dead, that power of attorney died with them. And if they let you have money out of that account, they're going to have to replace that money with their own money. That's not how banks make money. They don't know if the principal might have revoked it. If they revoke that power of attorney and the institution takes it, again, the institution is going to be liable for the result. They don't know if the principal is really incapacitated. They may want you to prove that. How are you going to do that? It's just not that easy to do. They don't know if fraud, duress, or forgery was involved in the creation of that power of attorney. So in any of these cases, the institution is liable to the principal for their money. So those are not the only reasons that powers of attorney fail, but these are the big reasons that powers of attorney fail. And when they fail, the question is, what is plan B? Well, let's look at how a guardianship works. An individual owns assets in their own name, or two or more individuals own an asset together, such as a house. One person becomes incapacitated. We don't have any other planning that will work. So we go to probate court for a guardianship of the estate and/or a guardianship of the person. Now, guardianship of the estate is much more difficult, and I'm going to walk you through that process. The guardianship of the person is easier. So guardianship is a solution to a problem. And the problem is a person is unable to sign their name on necessary documents to manage those assets. Guardianship solves that problem by having a judge authorize a substitute signature. And you go through a lot of rigmarole to get a judge to do that, as you're going to see. Guardianship is and frequently the only solution to the problem. After we look at guardianship, just ask yourself, is this the best way to solve this problem? It leads to a lot of time. It takes months to get a guardianship in place. It costs a lot of money. I'm going to show you the reasons why, but basically you're going to pay for 2 lawyers, a doctor, and a social study out of the estate. It involves a lot of going to court. Now, sometimes a case only goes to court for hearing one time, but it may take several trips. There's a loss of control. The person who becomes a ward of the court loses complete control over their life, and their family finds they don't have a lot of control either. There's a loss of dignity. Nobody wants to have their family go to court and say, my dad is incompetent, mom can't manage her affairs. It's embarrassing. It's also a major asset protection problem because it opens the door for creditors and predators that would otherwise be shut. All they have to do is bring their claim to a case that's already before the court. So here's an example. Carl and Myra have 3 kids, Peter, Paul, and Mary. Myra is terminally ill. She can't manage her assets or herself. And unfortunately, that happens a lot. Then Carl has Alzheimer's. Well, powers of attorney have failed. So let's take a little bit of a look at the assets. They have a $500,000 home. Carl has a $500,000 IRA. They've got 1.8 million in investment accounts managed in Carl's name. They've got $200,000 in joint bank accounts. And their old POAs are not valid. POAs are powers of attorney most of the time. So here's what we need. We need to get assets to provide for Carl and Myra. We need to sell the house. It's no longer feasible for either one of them to live in the house anymore. We need funds to take care of Myra so she can be in a facility, and Carl would be better off in a facility. So they started this process about a year ago, and it's still going on. They're still in their home. It's still a problem to their kids. Well, we need to get doctor's reports for both of them, and that's usually not terribly hard to get, though it is cheaper to go see a doctor and get them to prescribe something than to write a report in most cases. They need to hire an attorney to file 2 different guardianship applications proposing Peter as the financial guardian. They have to notice interested parties, and in this case, that's their kids. The judge has to appoint, well, in this case, the judge appointed the same attorney ad litem for both cases. Now, that doesn't always happen, particularly if there are kids from outside of the marriage. So if it's a yours and mine or yours, mine, and ours, the judge may appoint 2 different attorney ad litems, and that's going to complicate this matter. But here the judge did us a favor. There's no access to financial information or assets, but the kids do have statements they found at the house which tells them something about the assets. The court investigator does a background check on Peter. Now, for some time under COVID, courts were backlogged on background checks. And one of the things we learned when you go through a pandemic like that, it really slows the court system down. Peter has to qualify for a bond, and that means that he's going to have to pay out of pocket 3% of the assets under management. And that's $90,000. What if he doesn't have the money? Or what if he can't qualify? Now, this can ultimately be repaid in the probate process, but one of the kids or all of the kids are going to be out this money in the interim. Peter also has to undergo approved training as a guardian. Now, guardianship is one of those 12-step programs. The minimum cost of a high net worth guardianship like this is going to be $40,000. It's probably going to be more than that. And that's each. Not one $40,000 bill, two different ones. It could get worse if there's creditors or predators out there. The annual cost is typically going to be at least $10,000 in a case this size, but it's usually going to be more. And it seems like a constant stream of surprises that goes on for as long as that ward is alive. So unfortunately, that doesn't end once you get the guardianship in place. It keeps going. Guardianship is disastrous for otherwise good estate planning, business planning, or asset protection planning. Now, Carl moved to the same facility a year ago as Myra, and even though in 2020 it was possible to waive the RMD in Carl's IRA, Peter could not get the authority to do that in time. So that's another problem with guardianship. It may take a while, and the IRS deadlines don't change just because you've got a problem in the family like guardianship. That created an unnecessary tax on that distribution. Now, once we have the guardianship in place, then you're going to be able to do that stuff. But again, that process can take months. So within capacity, I'm going to show you the same chart we kind of looked at a while ago, but now I'm going to show you the trust. The trust incapacity is still an issue. However, the assets owned by the trust, that trust replaces the powers of attorney. It avoids guardianship. It can provide incapacity instructions. The successor trustee manages it. It's easier to manage, change, and update, but it works best when the assets are fully aligned with the trust, meaning the trust either owns them or those assets go to the trust. I'm not going to deal with business owner issues here, but just be aware if we're talking about business owners, this gets even more complicated. Now, a trust is a contract that involves three parties. The first one is the trust maker, sometimes called the creator, grantor, settlor, trustor. The trust maker makes up the rules of the game. The second party is the trustee. The trustee manages the trust. The trustee is the boss, and the trustee's job is to manage the assets for the beneficiary according to the instructions the trust maker created. The third party is a beneficiary. Now, typically, our clients serve in all three roles, and they can continue to do that as long as they're able. The trustee holds assets for the trust, and that's often stated as the trust owns the assets. While they're technically different for our purposes today, we're going to say the trust owns the assets. The assets that are in the trust avoid guardianship and probate. Now, Carl and Myra, this time we're going to assume they did a trust 3 years ago, right after Myra was diagnosed. Carl was not yet showing signs of Alzheimer's. So how is the typical trust going to work, assuming they get the assets transferred properly? Well, not all trusts are the same, but in this case, it worked really well. Myra felt it was best if Carl served with Mary, her daughter. Carl preferred to have Peter serve with him because Peter's the more financially savvy. So they compromised. They had Carl with a 40% vote, and then Peter, Paul, and Mary each with a 20% vote. That way, none of the kids get left out. When Mary needed to go into a facility, the trust provided instructions for her care. So for example, it said, these are the facility features that she would want if she had to go to a facility. Those instructions can be lifesavers for your trustees. It can save them a lot of time looking, because if you've got a checklist like that, you can go on the internet and find places close to you that meet the criteria. Well, in this case, 2 facilities fit the criteria, and they were both within 20 minutes of Mary's home. She's going to be the one primarily going to visit them. And they picked a place closest to Mary since she had a little more time and she lived closer to them. Now, once Myra's in a facility, the kids took care of all the bills. They took care of all the financial stuff. Carl could spend his time with Myra. Mary realized Carl, however, could not stay at home. And the kids served on an incapacity panel. That was something that they put in their trust. And the kids said, well, Carl is incapacitated. He can't manage assets. Now, effectively, that meant that Carl could be removed, but it isn't always necessary to do that. In this case, now it just goes to 2 of the 3 kids' votes. But they could remove Carl if that was really necessary. But third parties are used to dealing with the kids in this case, therefore they didn't have to go to the trouble to remove Carl. And they moved Carl to a facility without a doctor's statement. Now, the trust instructed them to use the same facility for both and even put them in the same room. Now, without those instructions, you could have under a court, you could have one at one facility and one at a different facility, and 2 people who love each other are now permanently separated. But you can fix that with good trust instructions. They were also able to avoid the unnecessary RMD in 2020 because they had control of the assets then. There was no fuss or issues with any third parties to handle things this way. It was as smooth as a situation like this could be. Now, the trust can handle incapacity much better than powers of attorney and way better than guardianship. It can replace powers of attorney that are very prone to failure. It can avoid the guardianship. It can provide instructions for care of an incapacitated person. And one such set of instructions is, what kind of facility features do you want? There's others in there as well. The successor trustee has far more authority than either an agent under a power of attorney or a guardian under the court's supervision. So when it comes to dealing with incapacity, a well-designed trust is way better than guardianship or powers of attorney. Now, what happens when a person dies? Well, everything goes through what I call the estate settlement cost funnel. There are 4 types of expenses that come out. The first one is administrative expenses. You are always going to have administrative expenses. And some administrative issues are, which administrative rules apply, how many different rules apply, and where do you put your family in this process? A second type of expense is probate expenses. Now, that's in red because it is possible to avoid probate. And then there are creditor or predator expenses. It is also possible to avoid predators. And then there are tax issues. And in case you're wondering, what's happening here is you've got water in this funnel, i.e. resources, and you turn on the spigot and those resources come out the spigot. And it's only when you've managed to turn all those spigots off and get through this process that the family gets what is left over. So keep this in mind when we ask, where do you put your family? You're going to see you don't have to put them at the bottom of the list. Now we're going to look at the 4 ways that assets pass on death. The first is joint with right of survivorship. It always will pass to individual survivors. If it doesn't pass by right of survivorship, we ask, does it have a beneficiary designation or a transfer on death designation? Now, I refer to this as planning by the box. The reason is, on that beneficiary form or TOD form, it says if something happened to you, where do you want the assets to go? Whatever you put in the box is going to dictate the rules. Now, these three may look very simple, but I'm going to show you, you can lose control over the assets and they will blow any tax planning you may have done. If it doesn't pass by right of survivorship or TOD, we ask, is it owned by a trust? If so, it passes according to the trust terms. If it isn't owned by a trust, the only thing left, it's owned by an individual, it goes to the probate estate, and it's controlled by will or intestate succession. Now, intestate succession is the will that our state legislature has graciously written for people who don't do their own or for those whose wills are determined to be invalid. When we have a trust-based plan, we use what's called a pour-over will so that it pays the assets to the trust. Now, while it does go through probate, at least the trust instructions control distributions. Now, in the box, you can put the trust, and you could also put the probate estate. The probate estate becomes the default in case the box goes wrong, i.e. the beneficiaries are not alive, and the TOD beneficiaries are not alive. Now, all four of these get assets to beneficiaries, but they're not equal in how they do it. So we're going to look at the administrative rules. Now, you always have to look at case law, banking regulations, the Internal Revenue Code, and the Treasury regs. But then each of these has a set of rules. And one of the things that you'll notice is that the first three, right of survivorship, beneficiary designation, and TOD, have one common set of rules. Notice that while they're not the same from the top to the bottom, once you get to the bottom, they're the same. Under the Internal Revenue Code, there are special bad tax rules that apply. Under right of survivorship, contract, which is beneficiary designation and TOD, in each state where there are owners, survivors, beneficiaries, or where assets are located, we have several laws that can come into play. The Estates or Probate Code, the Property Code, the Insurance Code, and the Family Code. And I'm going to give you an example of some of these. Then, if it's owned by a trust, we have one state code to deal with. If it's Texas, it's the Texas Trust Code. I know some of you are not in Texas. Maybe the good news for you is it would be whatever state you're in if that's where your trust is based. Then, if it's owned by an individual, in each state where they own a real property interest, you're going to go to probate court. You're going to deal with the estates in the probate code, the property code, and maybe other laws. Family code can particularly come into play here. Now, I'm just going to ask you to take a look at this chart and ask you real simply, which looks like the simplest way to administer an estate? If you notice that it's the blue box, the trust, you're right. It's easier than all these other ways of doing it. I did not say it was easy. I said it's easier. Some of these others can get really complicated. So Merlene died. She had 3 children, Harry, Don, and Norma. She died on a Sunday. 8 days later, Norma came to see us to probate her mom's will. The real estate market was really hot. She wanted to sell the house here. But 50% of the assets passed by right of survivorship and TOD or POD, and those were financial type assets. 30% passed by beneficiary designation, and 20% was going to pass through a will, and that involved a home here and a piece of property in Wisconsin. Both of her sons were in second marriages. And once I learned that, I asked Norma, how did Mom like her new daughters-in-law? The answer was she didn't like either one of them. Now, for Norma, She lives in Texas, first marriage, all the kids are from that marriage. She doesn't have any issues. And sometimes those things work well enough that people think they work well, even though there's a lot of things that can go wrong. Again, I mentioned the hot Texas real estate market explains why she wants to do this as quickly as possible. But they can't sell the Texas real estate until after the Texas probate. They can't sell the Wisconsin real estate until after the Texas probate and then the Wisconsin probate. So 80% of Norma's 1/3 goes to her outright within a month, but no protection. Whether that's an issue, we didn't address in this case, but if she gets sued, she would regret getting it that way. We're going to address the no protection in another case, so we will cover that. Harry's in a second marriage. He lives in Illinois, and 2 days after Norma came to see us, Harry dropped dead of a heart attack, 10 days after his mother. Now, 80% of his 1/3, look what happens to it. Right of survivorship vests in 5 days under both Texas and Illinois law. Not every state has the same law, so you then get to have a contest to see which state law is going to apply. The beneficiary designations in the TOD immediately vest. So what happens to what went to Harry? Well, that depends on Harry's plan, not Merlene's plan. Harry has a simple will with his new wife. It all goes to her. What about his minor children? Well, maybe there's some good news. The 20% from the will isn't going to go to Harry's estate because the will required that he survive Mom by 30 days. He did not. Therefore, it's going to go to his minor children. So they're going to get to go through a guardianship in Illinois. Look at this, folks. Merlene has lost control of 100% of what was going to Harry. 80% is going to somebody she doesn't like. The other 20% is going to go through a probate in Texas, a probate in Wisconsin, a probate in Illinois, and a guardianship in Illinois. That's not having control. What about Don? Well, Don's lives in Wisconsin, second marriage, kids prior to the marriage. Half of his 1/3 is from right of survivorship, TOD, and POD. Now, the bank tells him those assets have paid. He needs a new account. He learned that on Monday when he flew back to Wisconsin. He said to the bank, I'll be in tomorrow to open a new account. But the next morning, before he leaves the house, a process server shows up and he opens the package and finds out he's going to go through a divorce. He needs a lawyer. He spends the day chasing down a lawyer. What call does he get the next day? I bet a number of you don't know this, but remember, that's when they got the call that Harry died. So Don took his inheritance and put it in a joint account and goes to the funeral. That's a joint account with the wife who's suing him for divorce. That really happened. Well, we looked up the Wisconsin Family Code and found out when he did that, his wife became entitled to 1/3 of it. From Merlene's perspective, she has now lost control of 1/6 of what was going to Don. So 100% loss of control over Harry's, 1/6 of Don's, that's just a nightmare. Now, they're going to go through 2 probates, and they're non-liquid assets, home and property. Someone's going to have to put up the money for probate and be paid back from the sales. Well, Norma's the one who's here, but she may have to borrow from one of her brothers. I don't really know her financial situation. But someone's going to have to maintain those properties until they're sold. And if the husband's name is still on the deed, an additional probate is going to be necessary in each state where his name is on real property, but we're going to pretend that's not an issue here. And 1/3 is going to go to each child. But each case is different. Norma's 1/3 worked fine as far as getting it to her, but it wasn't simple. And all she got was the assets, no other benefits to her. She had to front the costs of probates in both states. Harry's estate couldn't assist because of his death. And for some reason, his wife had no interest in helping her in-laws. Don couldn't assist because of his divorce. Now that he's going through a divorce, he can't go spend money just any old way. That becomes subject to the review of a divorce court. So Norma could put the money back and be paid back on the sale of the properties. Now, if Norma has the money, that's not that big of a deal. But if she doesn't, maybe her husband could borrow money. Who knows what they're going to have to do. But, pardon me, it could have been a lot worse, but it could also have been a lot better. Harry's 1/3, like I say, it all went to his new spouse, or I'm sorry, 80% of it went to the new spouse, but look what happened to the grandchildren. Each grandchild is going to get their share at 18 or 21. Now, they've lost dad. The stepmom doesn't care about them. These kids are going to grow up without the benefits of things that dad and maybe even a mom, we don't really know why Harry was in a second marriage. But when they turn 18, they're going to get some money and they're going to feel like, wow, I finally have control of my life. And how long is it going to last? Most of the time, it won't last. They'll get a nice car, no college, complete disaster. Don's, his soon-to-be ex, is going to get 1/6. The remainder comes to him, but again, with no other benefits. Overall, for Don, very poor, but it's not the complete disaster that Harry's was. Now, probate is a solution to a problem. It's a solution to a problem like guardianship's a solution. You can decide whether it's a good solution or not. The problem is a person owns assets in his or her own name, they've died, and they're unable to sign necessary documents to transfer assets. We have a terrible time getting dead people to sign stuff. I don't know how it is they vote in some places. Apparently that's possible, but they can't sign documents. So probate solves that problem by having a judge authorize a substitute signature. And if some of this sounds familiar, it's like guardianship. Probate is sometimes the only solution to the problem. Is it the best solution? Well, let's define terms here. Probate is a legal technical term that means to prove up the will. Unfortunately, that causes a lot of miscommunication between the layman who call lawyer's office and asks about doing a probate. The lawyer answers in technical terms instead of the layman's definition, which is the court-supervised transfer of assets for someone who's died. Now, in probate, people want to know two things. How much does it cost, and how long does it take? No one who is being honest with you can give you a straight answer to those questions. The reason is there's too many unknowns. If you knew to ask, what you would ask is, who gets paid first and who controls this process? Well, let's take a look under Texas law. First party paid, funeral and last illness up to $15,000 if the court approves. Now, folks, when you see a phrase like if the court approves, let me explain that to you. Courts approve things because lawyers go argue them. It's expensive getting the court to approve something like that. Then comes the family allowance for up to 1 year if you have qualifying family members, surviving spouse, minor children, incapacitated adults. Then comes the cost of administration, attorney's fees, court costs, executor fees, preserving, safekeeping, managing the estate, unpaid guardianship fees. Now, I sometimes tell my funeral director friends and doctors that that's our favorite part because it's where we get paid, but you guys are actually ahead of us. And then I tell them, not really. We just made it appear that way. See, we don't have to take a probate case until we get paid. So really, lawyers get paid first. That probably doesn't surprise you. Then comes secured claims and tax liens, unpaid child support and interest, and then taxes, penalties, and interest. Yeah, I can hear y'all cheering. That's the IRS. Look at all these people Texas has in front of the IRS. Isn't that great? Cost of confinement if somebody was in jail or prison, repayment of medical assistance if they were on Medicaid or something like that, and then any other claims that are unsecured. So one issue that can come up is rental owner problems. They might not be able to collect rent until they're through probate. I've seen cases like that. Or they can't collect rent until you at least get an executor appointed and they have the authority to collect rent. Now, did you happen to notice who isn't on the list? It's the family. Family and loved ones are last on the list when you go through probate. Now, it's great to know the order, but who controls this process? Well, it's not the courts and it's not the lawyers. It's any of those people who make a claim anywhere from 1 to 9. Nobody can tell you how many claims will be made. Nobody can tell you how long it will take to resolve those claims. Nobody can tell you what it will cost to resolve those claims. So if somebody tells you that they can tell you the cost and time of probate, they'll lie to you about other things too. Let me tell you what probate is. This is my definition of it. And before I show it to you, I'm just going to tell you, I've given this to multiple probate judges and I've yet to have one disagree with me. Probate is a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. Now, what if Merlene had had a trust? Well, there would have been no probate, so faster and less expensive sale on both properties, no guardianships for minor children, 100% of the benefits after relatively low costs go to those Merlene wanted to see benefit. Norma's 1/3, part came the sale of real estate, all would be protected against a future divorce or a future lawsuit. Harry's 1/3, 100% would have gone to benefit Harry's minor children. There would have been no guardianship. It would have been controlled by a trustee until the grandchildren were older, and we would have mapped that out for Merlene when we did the trust. It can be used for their education and medical expenses, and it's all going to be protected against future divorces, future creditors, any existing creditors, future lawsuits. Whole lot better deal for the family. Don's 1/3 would have gone 100% to benefit Don. His soon-to-be ex would get 0. All of it would be protected in case he gets remarried and goes through another divorce. It would be protected from any existing creditors and future lawsuit creditors. So while you're alive, the trust owned or controlled assets avoid guardianship. The trusts, at least they should be in Texas, needs to have the language in them. But they can be a qualifying trust for homestead protection. So when you transfer your homestead into the trust, you don't lose any of the great homestead benefits that Texas law allows. They should identify family members, and We definitely prefer to see that they also give birth dates, because some things are based on age, and it's just easier if you see that in the document. They should name successor trustees. They should have incapacity instructions. They should have personal property distributions and rules in case of disputes. How do you resolve disputes? If it's a married couple, AB provisions, distribution provisions to beneficiaries, and then what I call the Titanic plan, i.e. everybody gets tickets to take a cruise on the Titanic and none of them get off. What happens then? Where do the assets go? They should have trustee powers. They should have trust administration rules. And then the last article in our trust I refer to as the kitchen sink article. It's where we put things that need to be in there but didn't fit logically somewhere else. So, folks, I'm just going to tell you that a trust that has all of this is not going to be a very short trust. It's not going to be 5 pages, 10, 20, 30, 40, 50 pages. They're lengthy for a reason. To do everything that you might need done, it's just going to take some paper. After death, assets owned or controlled by the trust avoid probate. We have distribution instructions for all assets. The family has faster access to assets. In fact, in probate, about the soonest, if things just go lickety-split, you're looking 2 months in probate. With trust, 7 to 14 days. The family can get control of assets. They're faster and easier to administer. Trust administration, a typical, relatively simple trust administration can be anywhere from 6 to 12 weeks, 6 weeks to 3 months. Now, more complicated ones are going to take longer, but in probate, the fastest you can get through probate in Texas is about 6 months. And the average time is somewhere between 8 and 16 months. Trust administration is way faster than going through probate. You also have fewer complex rules than right of survivorship, beneficiary designations, and probate. The trust itself provides most of the instructions, and the Texas Trust Code, assuming it's Texas, provides the rest. It involves only one state's law. In most cases, I am now dealing with a second case where we're having to deal with California law as well. We welcome all you California folks to come here, but just so you know, your trust creates some complications if we have to deal with both states' laws. The trust provides more certainty of results than any other distribution rules. Now, I don't want to spend a lot of time because, but every married couple should do an AB plan. It provides flexibility for future changes. Each spouse controls the distribution of their own share. You maintain government benefits for the survivor. You can provide asset protection for the surviving spouse, and that can help avoid accidentally disinheriting children, and most certainly not, accidentally disinheriting children is just plain sad, and it happens. That's what happened to Harry. He accidentally disinherited his children. Wasn't his intent, certainly wasn't his mom's intent. It can reduce friction in second marriages because you know where the assets are going to go. And for most people, one or more of these is way more important than the tax benefits. I haven't even identified the tax benefits up there, but I'll show you that on the next slide. In an AB plan, you get to use both exemptions. So the A side is the survivor's exemption. The B side is the decedent's exemption. Now, this you might find a little bit humorous. The A side actually stands for the above ground spouse. You're never going to believe what the B side stands for. The below ground spouse. I knew y'all never get that. But using both exemptions, we get to pass twice as much estate tax free. Now, let me share some things that happened in my family. First of all, I had a wonderful set of parents-in-law and great in-laws. I tried to talk them into doing a trust. I even offered to do the work for them, and I offered to get one of my colleagues in North Carolina to do the other documents at a discounted rate. And it's surprising who I got resistance from. I won't mention anybody's name, but after my mother-in-law died, she had a 3-page will. The rest of the family thought, oh, see, this is simple. I was like, no, that's a disaster. See, I know about this area of law, something they don't. And that is, the shorter the document you have to work with, the less it covers. So there was so little to the will, the family and the attorney had to fill in the blanks. Getting attorneys to fill in the blanks, that's more expensive. The probate was way more difficult than the family imagined, not because we had disputes. There just was more to it than the family had imagined. And one of them asked me, so what would this have been like if mom had had a trust? I was like, you really don't even want me to tell you. But instead of months and months and stress over this, it would have taken a few weeks. It would have been a cakewalk. They rented the townhouse that they still owed on. They rented it for years. Unfortunately, not picking on my brother-in-law, but he did not charge enough rent. And we would occasionally have to send money to cover some expense. It was very frustrating. Now, the stress over this seriously damaged the family relationship. So when her mom died in March, and this was in 2010, all 3 kids came in with their families, and we talked about, you know what, next June, 15 months from now, let's all go on a vacation together. We'll be kind of through this. We can just enjoy each other, and we'll get to enjoy each other as family instead of dealing with the stress of mom's death. The plan for that was to happen in June of 2011. We are still waiting for that vacation. It's never going to happen. Things that came up, unfortunately, were, they didn't tear the family apart, but the family is no longer the close unit it was before my mother-in-law died. And we've done stuff separately with my wife's brother and sister, but we've never all done something together. And that's a shame. Now, my mom's story is quite a bit different. After death, after my dad's death, there were 2 years of various struggles. And I tried to talk mom into going to a facility of some type. But I want you to get these dates. They're on the test at the end. On August the 6th, 2013, my mother called my brother and I and informed us that she wanted to move from Irving to San Antonio to an independent living facility by the end of the month. Now, literally before I got the phone back down to the desk, my brother called me. He was very concerned about the timing. He said, there's 1 million of these places in San Antonio. I've got to go to all of them, find out what they offer, bring mom to the most promising ones. This isn't going to happen in a month. We'll be lucky if it happens by the end of the year. And I said to my brother, John, you don't have to do any of that. In mom's trust, we have instructions for what type of facility features she would want. And she moved on August the 29th, 2013, 23 days after that phone call. Hope you got those dates down. You won't see them again until the test. Now, my mom's Irving home I had the fun job of getting to clean it out. Fortunately, I had 3 kids who could help by that point and a wife, and we had fun. The house in Irving was 40 minutes from where we live. And I'll just be real honest, my mom's house, apparently there had been a train wreck in there that got hit by a tornado. It was a disaster. So cleaning it out was not a lot of fun. Then we did an estate sale, all the stuff that was actually sellable. I won't even tell you how much trash we threw out of there, but it was a bunch. But then we did an estate sale. We arranged for all of that. And then I arranged for repairs to the house. And then we put it on the market. Now, this happened at the same time that Merlene's case happened. And we put it on the market on a Thursday afternoon, a little after 5 o'clock. And a little after 5 o'clock on Monday, I got a call from the realtor. And he said, I got some bad news for you. We only have 7 offers on the house, and only 6 of them are above your asking price. So I told him, well, please keep giving me that kind of bad news. We sold the house fairly quickly. We closed on the sale with only my signature. I didn't have to get mom's signature. I didn't have to get my brother's signature. I was able to handle that all on my own. I completely handled everything in Irving that had to be done. And instructions put in years before made that job much easier than it would have been without those instructions. My brother took care of everything in San Antonio. He lives down there, and he managed her facility care. I told him, okay, you found 2 facilities. All you got to do is pick the right one, John. Whichever one mom will be the least unhappy with is the one you need to pick. And my brother did a commendable job of picking a facility that mom was not terribly unhappy in. He managed her personal care appointments, hair appointments, doctor appointments, all that kind of stuff. And for 6 to 8 months, my mom was competent to manage assets, even though she didn't have to. My brother and I took care of everything. Then my mom became incapacitated, but none of the financial institutions we were dealing with realized that. They were used to dealing with my brother and I, and we didn't have any issues. My mother lived about 20 months, and she died in May of 2015. She died on her favorite day of the year, Mother's Day. We had her administration completed by December 31st, so we had no tax carryover from that trust. And then we divided the personal assets without issue. I will say this, my brother was a great person to divide an estate with. We literally had no issues at all. And when we were growing up, one of our friends used to say, it's a good thing y'all are brothers because you'll never be friends. We're actually best of friends. Now, we had provisions in her trust that could have resolved disputes, but they weren't needed in our case. And they are rarely actually needed, but when you need them to be there. I arranged mom's funeral with no help from mom. On multiple occasions, I said, Mom, I'm going to come over and we're going to work out your funeral arrangements. And she said, great, come ahead. And I would get there and she'd say, honey, let's do that next time. I got something else I want you to do. And sometimes I felt like it was like, rearranging the sock drawer or counting the stripes on the sheet or something completely useless. The funeral would have helped us, but my mom got the kind of funeral that I thought would be nice for her. She didn't complain, and neither did anybody else in the family. But my life would have been a lot easier if my mom had told me what she wanted. She gave us very little instructions. Then our inheritances were put in trust for us throughout this process. And the final tax return was due in 2016. And then my mom, I'm going to talk a little bit about predator dragons and how she kept it in trust for us. So we define asset protection as protecting and preserving assets from unnecessary loss. The biggest risk to your estate plan is your child's spouse's divorce lawyer. They are experts at taking your inheritance and getting it to their client instead of your kid. For that reason, you ought to protect your children. Beneficiary debts, there can be extraordinary bills, and I'll share a story of a friend of mine. We grew up on the same street together, and about 2.5 years ago, she stepped up on a single step stool to put something up in her kitchen cabinet, and she slipped and fell. She broke her leg, $324,000 hospital bill. I know that she has had 2 surgeries, and I don't know how much rehab, I don't know how much that cost, but that would wipe a lot of families out. Your kid might not have any control over something like that. Well, I don't know what kind of planning her parents have done, but it is possible to set it up so that those bills wouldn't come out of their inheritance. Then there are predator threats, future lawsuits. Those could happen to anybody. Does a beneficiary have a high lawsuit risk job? The other day, I was talking to a client and I asked, okay, what does your son do? He's a vascular surgeon in California. Okay, so California, they're crazy out there. You can sue your next door neighbor for something your other next door neighbor did. It's crazy. High risk. I said, you need to protect him, and they agreed. What state do they live in? I gave you an example of California. You know, if you're in a car accident in Massachusetts, as I'm going to show you, your kid can be 1% liable and lose everything. In California, if they heard about the accident, they could lose everything. I kind of hope I'm kidding, but how would the loss of those inherited assets affect your beneficiaries? See, this is the flying dragon that nobody's looking for. So when beneficiaries receive assets, there's 3 basic ways they can get it. They can get it in a pay outright trust. There's no protection for the beneficiaries. If they get sued, it's gone. If they go through guardianship, they go through probate, it's just out there with lots of risk. They could do a convenience trust. It has a limited amount of protection. First of all, it'll keep your kids' property separate property. It will avoid probate and guardianship. It might protect from a kid's bad money management, and it can protect from the IRS upon the child's death. So the other day, I'm dealing with a client who is below the exemption limit, which right now is 12.92 million. He's about half of that. But then he announces, yeah, mom's going to pass me about $7 million. And I realize you're going to inherit a tax problem. How nice would it be if you inherited, but it wasn't subject to estate tax? We could do that. Then there's a heritage trust. It offers full protection. Creditors and predators can't take it. Bad marriages, first death in marriage, loss of government benefits can protect against all of that and against the IRS for future generations. So what I'm going to do is just share a case history with you. Carrie was a young lady. She inherited $3 million from her parents. She was involved in a car accident in Massachusetts. Unfortunately, somebody trying to go around her at an intersection clipped her bumper, caused her to veer off. She T-boned a van load of daycare kids. It killed the driver and 2 kids. Well, there was a huge lawsuit over this accident. The case went to trial. The jury found the guy who hit Carrie 90% liable, but they found Carrie 10% liable. Now, how much does Carrie have to pay? You think 9.8 times 10%, that's $980,000, and that'd be a really good guess. But in Massachusetts, it's a pure joint and several liability state. That means that if you are deemed any liable, you can pay all of the claim. Carrie lost her entire inheritance over that accident. Compare that to another Massachusetts accident where Ted got a little too much elbow exercise one night and he failed to negotiate the bridge over the Chappaquiddick River, and Mary Jo Kopechne died. Ted Kennedy's parents, unlike Carrie's parents, had done what we refer to as a heritage trust. The Kopechne family could not get to any of that money. Now, anybody could be involved in an accident. You could be like Carrie, your kid could be like Carrie and be a ping pong ball in an accident, depending on the state where it happens. And who knows, the jury just might not like her lawyer, might not like her. Who knows? Juries don't always arrive at the right decision, in my opinion, though I think the jury system generally gets there. But most parents don't want to control from the grave, at least not for long. However, they do want to protect their beneficiaries. The good news is you can do both. So we can give assets to your kids in heritage trusts, like the Kennedys did, and still give your child a fair amount of control over it. In fact, a whole lot of control. My brother and I have heritage trusts from our parents. I'm his co-trustee, he's mine. Now, one of the things that my brother was a little concerned about at first is, well, what if I want to buy a house and you say no? And I told him, I don't care what you want to invest in. The only person I'm going to say no to is somebody who sues you. And if somebody sues me and they want to get out of my heritage trust, I tell them, good luck. You get to deal with the world's most stubborn, hard-headed person. I know. I grew up with him. He's my kid brother, and he's protecting me. And yet, I still have a great deal of control over those assets. So, that's a lot of the stuff that trusts can, and in my opinion, should protect you from. I've given you details comparing for you trust versus wills, multiple states involved, the ways that you pass assets to kids, specific things in there, and personal experience that we've had on both sides of my family. And you can kind of see there's a big difference. One of the things my wife talked about, I told her I was going to share what happened with my mom. She says, why don't you share what happened to my mom? And I was like, wow, you would give me permission to do that in front of 3,287,826 people? And she said, yes. So that's why I told you the story of my mother-in-law. Anyway, thank you for listening. I went a little over what I intended to go, but do we have any questions?
Well, yes, we do.
Well, you're doing that. Let me go over the CEU stuff real quick first.
All right.
Oh, no, that's all right. Go ahead. You got plenty of time to go over some questions. I'm sorry.
And I did write them down. I hope that I did this correctly, writing them down in the order that I saw them. So the first question, and she actually has two. It's from Shamika. Okay. What is the difference between an advance directive and a medical power of attorney?
That's a really good question. Some of it may be semantics. It may depend on what state you're in. In Texas, we have the medical power of attorney, the HIPAA patient authorization, and the living will. all are part of a group of documents known as advanced directives, though they are distinct. But those are the three big documents that you need: HIPAA authorization to allow somebody to get medical information, medical power of attorney so that somebody has authority to make decisions. And the living will is the document that allows doctors to pull the plug if you're terminally ill and there's nothing they can do for you. There's a couple of other documents in Texas that I won't take time to go into, but sometimes those three documents are referred to as advanced directives.
Okay. Her second question is, why would one choose to do a guardianship versus a trust?
I have never had somebody who went through a guardianship make that choice. People go through a guardianship because they haven't planned to avoid it, and they've not ever been through the experience, so they don't know what a guardianship is going to be like. And then after they get in it, I've never had somebody who wanted to go through guardianship again.
Okay, next question is from Anonymous. How much does it cost to set up a trust? And are there any resources for those who are low income?
So the first question, I can give you a very broad range. Talking about a living trust-based plan, it's going to depend on single, married, whether you want to do a customized trust, whether you're going to have the heritage trust, AV planning. Going to be, at least in our office, anywhere from $2,500 up to maybe $9,000. Are there resources available for low income? Sometimes there can be. I don't know what somebody like Legal Aid does, but
we're getting ready to put together a webinar on that. In fact, I've got one presenter, I'm waiting on the other one. We're getting ready to put together a webinar. We're hoping to have it in the middle of May on legal aid for low-income people in Texas and what different agencies provide that.
Okay.
Awesome. Okay, next question, also anonymous. Why do certain assets require that a spouse sign off if the owner doesn't want to have the spouse as a beneficiary?
Typically, you're talking about retirement plan assets, and that actually has to do with federal law. That if you're not going to give your spouse the retirement plan, your spouse has to sign off and agree to that.
That's because it would be community property? Not
necessarily. It's because it's what's called an ERISA plan, i.e. like a 401k, 403b, or something like that, which are controlled by ERISA, whereas IRAs have a lot higher level of state control.
Rex, explain what ERISA is, because people may not know that.
ERISA was a law passed in 1974. I think Retirement Income Security Act is what the ERISA stands for. Oh, Employer Retirement Income Security Act.
Okay, good. Thank you. Yeah. All right, next, Melissa. Please fill in the blank. If your family assets are over blank, you may want to consider a trust.
It is not a matter of how much money a family has. It's a matter of how much would it cost a family in a small estate to go through a guardianship, to go through a probate. How much does it cost to lose control? We've done trusts for people that have $20,000, $30,000 in assets because it's cheaper than dealing with the other things. Now that would be really on the low end. But think of it as a tool that does things for you, not as something based on a dollar amount.
Okay. Jennifer would like to know, what can probate cost?
Probate typically is going to cost $5,500 and up per probate. There's a lot of factors that go into that. I have a colleague out there that he tells me that their average probate's about $12,000. That's more than our average probate, but it can be awfully hard to compare cost because you don't really know what all they're having to deal with.
And I'm glad that you mentioned earlier, because I hear this, even though I'm not an attorney, I hear this in this office all the time. People keep calling to say, why is their probate taking so long? Well, you have to understand something. We do not set the court dates. They do. The courts set the dates. And if you're in Dallas County, Rex has expounded on how long that can possibly take. So I hope you understood that. Collin County is not near as bad, but Dallas County, oh my. And it's not our firm or anybody else's firm that's the problem. It's the court system. So it's unfortunate, but you have to understand that. And I'm glad he brought that up.
I would go to great lengths to avoid probate in Dallas County. I just would, folks. And a lot of attorneys feel that way who practice probate.
Okay, the next question is from Diana. What do we do, or where do we send individuals with dementia or Alzheimer's that need to have a POA completed to receive treatments?
That's a mess, because if they can't legally sign a POA, you're looking at guardianship. If they can, a lot of attorneys do that, us among them, but it's going to depend on whether they are legally competent to sign documents.
And can I just make the point
Yeah.
that it is really, really, really important that, especially all of you professionals, that at the minute you see any kind of memory issues, you get this stuff taken care of.
Yes.
Because it's a nightmare if you wait.
Well, and Rex, can we go further with that? Explain how you determine someone's capacity. If you're the one dealing with them and the loved one has brought them in and say, my mom is okay, she knows this, what do you say to them?
Well, this may vary depending on the facts a little bit, but typically we're going to want to talk to mom independently and determine that mom knows who her kids are. Mom knows they're the natural objects of her bounty, that mom wants one or more of the children to act on her behalf. We had a case where we had two girls, and one of them did a lot of influencing of mom. We could see that in the meeting, and so the next time they came in, we separated her and mom. And when we didn't have that daughter in the room, we got a very different story than what we got when that daughter was in the room. And we could see it. She would say, Mom, this is what you wanted to do, remember? Well, privately, Mom said, no, that's not really what I wanted. So I'm going to say that's relatively rare. The daughter set it up so that she and her husband could be in control of everything and her sister would be in control of nothing. That is not good. So if mom can't function with either kid there or any of the kids there, that's a problem. If she can't answer our questions.
Thank you, because I know people do not understand that.
Yep.
Okay, the next two are from Jan. What's the trust protector? How do they get paid? What do they charge once the grantor has passed?
So a trust protector is a role for their job is to protect from things that we cannot predict in the planning process. As an example, we can't predict when maybe a co-trustee is in the military and they get shipped overseas to go to war. We've had that issue come up. We can't predict that Congress is going to come along and change the law in 2 years after the trust is done, and then a person dies afterwards. There's a number of issues that come up. As for how much the trust protector charges, it's going to depend on what you're asking them to do. We had a trust protector one time that I took him to lunch at Babe's Chicken and got him to sign an order, and he did not charge our client anything other than the cost of lunch. That is extremely rare. It's low, but it was a very simple matter. Sometimes we're dealing with things that are extremely complex, but most of the time it's relatively routine, and they get paid out of the trust assets.
Okay. Next question. Why do people say that a living trust does not protect the home sale? Only the owner's name shows on the property. Home. No, he must be talking about home. Homestead rather than state. Okay. Why do people say that the living trust won't protect the homestead? Only the owner's name shows on the property, homestead, county appraisal record.
So what's on the county appraisal records is irrelevant. It's what's in deed records that counts. And if you have a qualifying trust, when we file a deed in the homestead, we actually say on there, this is a homestead deed and this trust is a qualifying trust. But if people say that, they just either don't know Texas law, or some of them who say that don't like trusts and don't want to admit how good they are at dealing with that.
Okay. Next question is from Sheila. Will life insurance payouts be involved in probate?
Well, the hope is that they won't be, but realize that if, let's say that you name a child and you don't have a backup and that child dies, then yeah, it goes to probate because your beneficiary died. So it doesn't necessarily avoid probate.
Okay,
fact,
her next question is along with that. Okay, she asked, if one spouse dies, will the joint assets automatically go to the surviving spouse, or is there a need for a trust in the scenario?
Nothing happens automatically in our world. So if one spouse is the right of survivorship, then the last one standing wins. And that appears to happen automatically, though you typically have to show a death certificate, you have to retitle the assets. But the problem is you've now blown any tax planning the first decedent did. So leaving assets directly to a spouse instead of to a trust, the trust is much better. Life insurance, for example, we had a case years ago that one spouse died in a car accident. The surviving spouse was also in the vehicle and incapacitated, could not cash the insurance check. Ended up having to go through a guardianship, even though the spouse was named as the beneficiary, the spouse could not legally sign the check. If the trust had been the beneficiary, the insurance company would have written a check to the trustee. The trustee could have used it to take care of mom. I have like 500,000 stories like that. So
can we stop and go through the CEU? We're right at the end. And then if you guys are willing to go on and answer more questions, that'd be wonderful. If you need to go, I understand. But Sheila, why don't you start by going through these?
Sure. Okay. Once again, either later today, because I'll send those to you, Marty, as soon as we get off here, the documents that I need to be sent back to me, which are the sign-in sheet and the evaluation form. Now, once you fill those out and return those to me, not to Marty, that's where some of this gets goofed up. People send it back to Marty and then wonder why he doesn't send them a certificate. So if you will send them to me, then I will be more than happy to issue you our certificate.
In addition to Sheila's stuff, there's also a Google survey that we ask you to complete. That helps us. It should pop up as you log out of the Zoom today. If it doesn't pop up, you'll receive that in the follow-up email as well, that link. But there should be an option as you log out. Sometimes pop-up blockers do that. Let me make a point. Please, I'm always suspect of people that are looking for CEUs that send me an email today or tomorrow or a week from now going, I attended the thing, how do I get my CEUs? Well, if you're responsible, if you're listening today and you're listening in order to get CEUs, and we go over this twice during the webinar, I feel like it's your responsibility to have been on to listen to this at least one time. And so I'm going to refer you right back to the webinar or to the slides, to the instructions, because if you're a professional needing CEUs, you should have got this out of the one or two. And now that we have 250, 300 people on, it's just hard to be able to manage all of those emails because of the fact that that you've got to be listening and do this the way it's supposed to. I'm just throwing that out. Sorry.
All right, I have about 5 more questions. Rex, are you okay with answering 5 more questions?
Sure.
Okay. Deborah asked, in a living trust, when the principal passes, will the trustee be responsible for their debts?
No. Beneficiaries are not liable for the debts of their parents.
That's awesome. Okay, now on to this.
Someone asked, how do they start a trust?
That's a good, yeah, I saw that.
Contact a law firm like ours and start the process. Typically getting a trust in place in our office anyway involves 3 meetings, an initial consultation, a plan design, and then come in for review and signing. Different firms may do it different ways, but yeah.
I just need to make the point that there's lots of attorneys that do this. You can, Heyman Hogue does this, but you can go to any attorney of your choice that does estate planning, and they will do that with you.
Right.
You just have to make
Yes.
that part.
Okay, Cheryl asked, if my trust was drawn up in Arkansas, but we moved to Texas at my death, will Texas or Arkansas laws apply in distribution of assets?
Typically, it's going to be Arkansas law if you haven't changed it. And just a little note that if you have a home that you put in your Arkansas trust, under Texas law, you will lose your homestead exemption. And eventually they figured that out and zap you for taxes and you lose the asset protection. So if you have an out-of-state trust, folks, when you move to Texas, you need to have it reviewed, and especially if you buy a home here.
Okay, next question from Nancy. Is a living trust possible for parents who have an adult disabled child where the parent's will sets up a special needs trust upon parent death to protect DAC's government benefits?
Yes, we do a lot of special needs trusts inside the living trust. In fact, anytime we're doing a heritage trust, we have the basic elements to do the special needs trust as well. The special needs trust can work very well inside of a trust, and it avoids probate.
Okay, if you put life insurance inside a trust, how is the premium payment managed?
Same way it is when it's outside. The trust, I mean, hopefully you're getting the bank account and the trust as well. You just pay the premiums out of the bank account. And then you name the trust as the owner, you name the trust as the beneficiary.
Okay. Two people want to know, how does a living trust work with a special needs trust?
Great question. There's really kind of two ways. A living trust done for the parent while they're alive can have a special needs trust in it for a beneficiary after death. They can also do a separate special needs trust for a child while the parent is still alive. And I'm not sure if that is answering the question that they're asking, because I don't really know what they mean by how does it work. It does work with a living trust or a separate special needs trust, assuming they're designed correctly.
Okay, Dave. Oh, go ahead.
Quickly, could you answer the question of revocable versus irrevocable?
Yes. Typically, a revocable trust is one that you can easily change or modify during your lifetime. An irrevocable trust is one that is not as easy to change. You use them, we do a fair number of both of them. They're used for very different things. Typically, a revocable trust is what you set up for your benefit while you're alive. You control the assets, you're the trustee, you're the beneficiary. An irrevocable trust is typically set up for another person, not yourself.
Such as Medicaid planning or something like that, right?
Yes, that's an example. Though people are, if they're setting up a true Medicaid trust for maybe, let's say that they're trying to get the husband Medicaid benefits, then that Medicaid trust, technically somebody else in the family is setting that up. I'm not the Medicaid expert in the office, so if I'm a little off on the technical answer here, please forgive me, but generally the couple can plan together to do a Medicaid trust, assuming the person qualifies for Medicaid.
Okay. Does the sale of a home out of the trust require any certain process, or do you just get a realtor?
You can just get a realtor. The only thing that truly changes is that when you sell it as a trustee instead of an individual.
Okay, what estate planning do you recommend for those who have more debt than assets or only have life insurance?
Okay, they're two different questions. Honestly, if they have more debts than assets, even with a trust, you're not going to wind up with a lot of assets going to the kids. Now, with life insurance, it's different. You can make life insurance be owned by the trust. You can have it paid to the trust so that the trust controls the distribution of that insurance. And that can protect beneficiaries from guardianship, probate. It also is a great asset protection tool. I tell people life insurance is really the magic bullet of estate planning. It's not generally subject to income tax, and it's not generally subject to the debts of the insured, and it's not subject to the debts of the decedent if it's handled correctly.
Okay. Next, must a guardian obtain court approval to receive payment from the trust?
So typically the court doesn't have control over a trust. So the guardian would not normally have to obtain court approval unless there was some kind of an issue that required a court to become involved in the trust process.
Okay. Is tax planning necessary or beneficial when individuals are not high net worth?
Well, yes, but you kind of have to define. For example, I said married couples ought to have an AB plan. That is commonly thought of as a tax plan, but the real reasons for it, the benefits, are mostly non-tax benefits. Other assets like retirement plans have specific income tax rules, and if you don't do those correctly, you'll create a higher income tax bill than is necessary, and you'll lose the ability to stretch it out for the 10 years under the Secure Act. So yes, sometimes you need tax planning even though you don't have a large estate. And another thing is, how do you deal with things like capital gains taxes, the stepped up tax basis on death? There's a lot of tax issues that aren't necessarily high-end planning issues.
Okay. Is this the best option for a lifelong couple who haven't married? The home is jointly owned. Each has children from previous marriages.
Well, yes, it is. They should each have their own separate trusts. But I will tell you that one of the problems that people have when they're not married, you really don't know what the rules are. And I'll give you an example. I had a gentleman approach me a number of years ago. He had been living with this lady, claimed that they weren't married, but he was about to get married to someone else. He had not lived with this lady for a while. And he starts describing to me what kind of relationship they had. They claimed to be husband and wife, which under Texas law creates a common law marriage. And I said to him, you really need to go through a divorce before you get married to the new one, because otherwise you're going to have a little bigamy issue. And he was not happy to hear that news. But sometimes people have done things and they don't know when they're living together. The other thing that can come up, if the couple are standing there, let's say talking to Joe, and the wife says, yeah, we're married, and the husband doesn't say anything, well, he's considered to have agreed. But what if he's not paying attention to what Joe says? Or what if Joe conspires with the wife to do that? So if y'all can't tell, I'm not a fan of living together where the rules are unclear. If you're going to do that, at least spell out in the planning what you intend and do some kind of property agreement.
Okay, well, this has been just incredible. Rex, Sheila, thank you so much. I really appreciate you. I mean, you guys have gone almost 15 minutes over the time that you agreed to. I'm so grateful for you all doing it. It was true, as you've seen, very, very informative. Truly grateful for you taking the time to do that. We all appreciate you joining us. I've even seen some questions now in the chats of, please send me an email of how do I get my CEUs? Well, we've gone over that twice. Just so you know, I'll be sending the documents and I'll be referring you back to the slides if you need any more information on it. because again, I just feel like professionals need to be able to be on for at least one of the times that we've described how to get your CEUs. But thank you so much, Sheila, Rex, thank you very much. Thanks y'all for joining us, and you all have a wonderful day. Take care.
Okay.
Thank you so much.